She was conscious, moving around the room, bleeding, and nobody came. That single detail, buried inside a sealed autopsy report, was kept from the very people who had the power to demand a trial, and by the time they learned it, the deal was already done. On July 2nd, 2025, Bryan Kohberger stood in a Boise courtroom and answered yes to each victim's name, expressionless, unhurried, guilty on all 4 counts of first-degree murder, in exchange for his life. No trial, no testimony, no cross-examination. The case that consumed an entire nation folded in a single morning, and the families of 4 murdered college students walked out of that courthouse with answers to almost nothing. But here is what the system did not anticipate. The guilty plea triggered the unsealing of thousands of documents that were never meant to surface this way. Autopsy reports, crime scene analysis, behavioral records, expert findings that were prepared for a trial that never happened. And what those documents revealed did not match what the families had been told, what prosecutors had disclosed, or what the public had been allowed to see. If you want the truth about what happened on November 13th, 2022, and everything that followed, you are already in the right place. Hit that like button right now, and subscribe to Keith's Crime Files, because this series is going where the courtroom never went. The autopsy reports were the first shock. Kaylee Goncalves sustained 24 separate injuries to her head and neck, 11 to her chest. Maddie Mogen sustained 13 injuries to her head and neck, 5 to her chest. Xana Kernodle sustained 23 injuries to her head and neck, 7 to her chest, and 25 to her lower extremities. Chapin sustained 6 injuries to his lower extremities. These are not summaries. These are the documented findings from official forensic examination, and they paint a picture of violence that is almost impossible to sit with. But it was not the numbers themselves that broke the case open. It was what the numbers meant when read alongside the physical evidence from inside that house. Kaylee and Maddie showed no blood on their feet. Forensic analysis concluded they had not moved after being attacked. The injuries were immediate and catastrophic. But Xana Kernodle had blood on her feet, significant amounts. The forensic conclusion was that she had been conscious and mobile after sustaining her wounds. She had been moving around the room, aware, bleeding, and alone. Steve Goncalves, Kaylee's father, read the complete autopsy reports for the first time when they became public after the plea. Not before. During the negotiations, the families had been provided a 21-page summary covering only their own child's report. Not the full documentation. Not the findings for all 4 victims. When Steve learned the full scope of what Xana had endured after being wounded, he made a statement that clarified everything. He said that had he known, he would have refused the plea deal entirely and demanded that this case go to trial. That is not a grieving father venting frustration. That is a man describing a deliberate withholding of information during a process that required his informed participation. The question of whether that withholding was procedurally appropriate or morally defensible would never be answered in a courtroom, because there was no courtroom. The competing forensic theories that were prepared for trial are equally important to understand, because they represent the scientific arguments that a jury was supposed to evaluate, and never did. The prosecution's expert concluded that all physical evidence pointed to a single perpetrator operating alone. The defense expert argued something fundamentally different. The crime scene patterns, in the defense expert's analysis, suggested the involvement of more than one attacker. The bodies appeared deliberately positioned. The timeline, the defense argued, was logistically impossible for a single individual to complete alone. These competing positions would have been tested, challenged, and evaluated under cross-examination before a jury. Instead, they exist as prepared arguments in sealed documents that are only now reaching the public. What the defense theory could not account for, and what the prosecution's evidence addressed directly, was the DNA evidence on the knife sheath. A car-bar knife sheath was recovered at the crime scene, and it contained Bryan Kohberger's DNA. But the defense expert claimed it had been deliberately planted, staged after the fact to implicate Kohberger. The forensic response to that claim was definitive. The sheath contained not only Kohberger's DNA, but also aspirated blood from the victims. Aspirated blood is blood expelled under pressure, the kind produced during active violence, not after the fact. Blood that is placed on an object after a crime does not aspirate. The sheath was present during the attack itself. The biology made that conclusion unavoidable. The documents also revealed something that had never been formally disclosed to the public in full. Bryan Kohberger's behavior at Washington State University had been documented not once, not twice, but 13 separate times before the murders occurred. 13 formal complaints, not rumors, not whispered concerns between colleagues. Formal, documented records within the university system, filed by multiple people, covering a pattern of behavior that escalated consistently throughout the months he spent on campus. When Kohberger arrived at Washington State University in the summer of 2022 to begin his Ph.D. program in criminal justice and criminology, people who encountered him described him as socially awkward and isolated. Within weeks, that description began to change. A female staff member reported that he would stand outside her office door and stare at her without speaking. When she left for the day, he followed her vehicle. A second female CO worker reported experiencing the identical behavior. The pattern was consistent enough that university leadership made the decision to implement mandatory professional conduct training specifically in response to the complaints. Kohberger attended that training. He sat at the back of the room, with his hands placed behind his head, and stared at the ceiling for the duration. His body communicated, without ambiguity, that he considered the exercise beneath him. In academic settings, he dominated class discussions and repeatedly challenged female professors. When one female professor presented her own peer-reviewed research on eyewitness misidentification, Kohberger became agitated and refused to accept her findings. When a different female professor assigned him a grade he disagreed with, he did not address her directly. He went to a male professor instead, and lodged his complaint there. Multiple female graduate students reported that he would physically position himself in their office doorways, continuing conversations while making it impossible for them to leave. The behavior became so recognized and so consistent that other female students developed an informal system, deliberately entering those offices as an intervention to help their trapped classmates get out. Nearly every person who filed a formal complaint mentioned one specific behavior above all others: his staring. Not occasional eye contact. Sustained, deliberate, uncomfortable visual focus, directed primarily at women, maintained far beyond the point where anyone would look away. One female student reported that after Kohberger had visited her apartment, she became convinced he had gone through her medicine cabinet. He later referenced specific details about her prescriptions that she had never shared with anyone. Another female student discovered footprints outside her residence, leading directly to her back window. She later learned that Kohberger lived nearby. After Thanksgiving of 2022, students at Washington State University began noticing that Kohberger had bandages on his left hand. When asked about it, he told people he was a boxer. Nobody at the university had ever known him to box. A student seated approximately 3 feet from him examined the wound, and later described it as looking like damage caused by asphalt scraping across skin, not the kind of impact injury consistent with boxing. After the 13th of November, his entire presence on campus shifted. He stopped dominating discussions. He became withdrawn. His appearance became noticeably disheveled. He began wearing a thick, heavy black coat every day, regardless of whether the weather required it. He stopped bringing his phone to class, and instead carried a laptop that he reportedly never used during sessions. 13 documented complaints, mandatory intervention training, multiple formal conversations with university staff, and Bryan Kohberger remained a student in good standing. He retained full access to campus. He continued attending classes, interacting with, peers, and operating without meaningful consequence. This became the center of the Goncalves family's most pointed criticism following the plea, that the warning signs were not just present, they were formally recorded, and the institutional response was not sufficient to protect anyone. The cell phone evidence extended the picture beyond the university campus. Prosecutors obtained Kohberger's phone records, covering the period from July 9, 2022, when he arrived at Washington State University, through November 13, 2022. During those months, his phone registered near the victim's residence at 1122 King Road in Moscow, Idaho, between 20 and 23 times. Those visits occurred almost exclusively between 10 in the evening and the early morning hours, times when there was no legitimate academic, social, or professional reason for him to be in that area. After sentencing, prosecutor Bill Thompson appeared publicly and addressed this evidence directly. Thompson stated that prosecutors believed those trips involved Kohberger surveilling and stalking the residents. He described how experts established that Kohberger was in that area over 20 times at night, when there was no legitimate reason for him to be there. Despite that belief, stalking charges were never filed. Thompson's stated reasoning was strategic. He wanted a clean, factual guilty plea. Adding stalking charges would have introduced complexity into the agreement. It risked giving Kohberger an opening to narrate his own version of events while entering the plea, which could have created grounds for the judge to reject the agreement entirely. By limiting the charges to murder and burglary, Thompson secured an unambiguous, uncontested guilty plea. The practical consequence of that decision was that the full scope of what Kohberger did before the 13th of November was never formally established in a legal proceeding. The 20-plus nighttime visits, the pattern of surveillance, the question of whether he specifically selected these 4 individuals based on prior observation, whether he had mapped the house layout in advance, whether the murders were the product of months of deliberate planning. These questions exist in the record. They have no formal legal answer. Kaylee herself had told her roommates approximately 1 month before the murders that she had noticed a man watching her from apartments above their residence while she was outside with her dog. 2 to 3 weeks before the murders, she reported that a man had followed her from a grocery store and was standing beside her car when she tried to leave. In that same period, the roommates returned home to find their front door standing wide open. Concerned enough to take it seriously, they retrieved golf clubs and searched the house together before concluding it was safe. Prosecutors acknowledged awareness of these incidents, but noted that phone records could not place Kohberger's device in those specific locations at those precise moments. The incidents the victims reported did not align perfectly with the phone pings investigators could document. What remained was a pattern of over 20 nighttime visits, victim accounts of being watched and followed, and a prosecution that believed stalking occurred but chose not to charge it. Dylan Mortensen was asleep in an upstairs bedroom when something pulled her awake around 4 in the morning. She heard music, then Kaylee's voice singing, then footsteps moving on the stairs, then Kaylee's voice again, urgent this time, frantic, saying 3 words, "Someone's here." The family dog, Murphy, began barking. Murphy rarely barked. Dylan heard what she believed was Kaylee moving quickly down the stairs, identified by the distinctive sound of Doc Martin's boots striking the steps at pace. Between 4:19 and 4:27 in the morning, Dylan called Xana, called Kaylee, called Xana again, sent a text to Kaylee. Not one of them answered. Then she heard a male voice, a voice she did not recognize. The voice said something that approximated the words, "It's okay. I'm going to help you." The tone was calm, almost gentle, not aggressive, not panicked, not threatening, just calm. A female voice was crying. Dylan initially believed it was Kaylee. She later reconsidered and thought it may have been Xana. When Dylan opened her bedroom door, she saw a figure dressed entirely in black. A mask covered the face. The figure was holding something she described as cylindrical and triangular, standing approximately 3 feet from her doorway. She estimated the height at around 6 feet. The build was described as athletic, but not heavily muscular. The skin visible through the eye holes of the mask was light. The eyebrows were notably thick and distinctive. That eyebrow detail would later be confirmed independently when WSU classmates, in separate investigative interviews, mentioned Kohberger's eyebrows as a recognizable feature of his appearance. The figure did not approach Dylan's room. It walked toward the sliding glass door, looked directly at her before leaving, and was gone. Dylan and the other surviving roommate, Bethany Funker, locked themselves inside Bethany's downstairs bedroom. They stayed there until they saw ambulances arriving outside. Dylan later acknowledged that she had been drinking at parties earlier that evening, and stated clearly that she was not entirely certain whether portions of what she experienced were real or whether fear and intoxication had shaped her memory. What she remained consistent and certain about was the male voice, the female crying, and the masked figure in black. Dylan Mortensen fully cooperated with investigators. She provided her DNA voluntarily. She gave detailed accounts to law enforcement, and she never testified at trial because there was no trial. The only living witness who saw the killer inside that house, who heard his voice, who looked at his face, carried all of that forward without a courtroom ever formally receiving it. When the guilty plea was entered, and thousands of sealed documents became public simultaneously, Idaho State Police released hundreds of crime scene photographs as part of that disclosure. Among those images were photographs that clearly showed at least one victim's body. A staff member called Kaylee's family to notify them. The message was brief. The photographs were going to be released online within the next few hours. By the time the family reached the Idaho State Police website, the images were already live. They contacted authorities immediately. The photos were pulled from the official site, but the window had already closed. Screenshots had been taken. Downloads had been completed. The images were already being shared and archived across multiple platforms. Nobody had warned the families with enough time to act. Nobody had consulted them before the decision to release was made. The photographs disappeared from the official page, but they did not disappear from the internet. Once released, nothing can be recalled. That is the permanent, irreversible reality the families were left with, and it added a dimension of institutional failure to a case already full of them. This is the evidence the courtroom never formally examined. This is the record that exists because a plea deal was accepted before a jury ever heard a word. And there is still more to cover. And then the people who were supposed to protect what remained of their children's dignity added another wound on top of everything else. When those crime scene photographs spread across the internet, content creators began downloading them, placing their own logos on them, their own watermarks, their own branding. They were monetizing intimate images of murdered college students, building audiences, generating revenue, and the families of those students had no legal mechanism to stop it. The versions circulating online bore watermarks suggesting they may have been altered or were unverified, which created an additional problem. When the Goncalves family requested official unaltered copies directly from authorities, so they could at least know what was being circulated in their daughter's name, they were told they had to go through formal legal channels. Content creators were sharing the photographs freely. The family of the victim had to file paperwork. That contradiction became one of the defining symbols of how broken the process had been from the beginning. The families could not access their own daughter's private medical evaluations or mental health records. Those materials were protected under privacy law. Bryan Kohberger retained legal privacy rights that prevented the families from seeing documentation about him. But the world had unrestricted access to autopsy reports and crime scene photographs of their murdered children. A convicted murderer's records were shielded. The victims had no equivalent protection. Steve Goncalves described this as feeling backwards in a way that was almost impossible to articulate. The person who destroyed 4 lives retained more legal protection than those 4 lives themselves. That imbalance did not happen accidentally. It was the product of a legal framework that was never designed with victims' families at the center of its considerations. The Goncalves family responded by taking the fight beyond interviews and public statements. They began working directly toward changing Idaho law. They met with Governor Brad Little's office to discuss legislation that would establish concrete protections for victims' families in cases involving sensitive document releases. What they were asking for was not complicated. Advance notification before materials become public. Meaningful input in decisions about document releases. Privacy protections extended to deceased victims that would be at least comparable to the protections extended to the living. They were asking the system to treat their children as though their dignity still mattered after death. That request should not have required legislation. The fact that it did says something significant about where the system's priorities had been placed. Steve and Christy Goncalves described the ongoing emotional cost of what they were being forced to endure. They read clinical descriptions of Kaylee's injuries repeatedly, in legal documents, in media coverage, in online discussions. They encountered crime scene photographs in contexts they had no control over. They watched strangers debate and dissect the most violent and intimate moments of their daughter's death as though it were entertainment. Christy described the experience of opening boxes that had been packed when Kaylee left for college, finding her hairbrush, her retainers, clothing she had worn in photographs that were now circulating on platforms neither of them could control. The sentencing had not closed anything. Every day brought new exposure to new material, and the process of grieving could not proceed in any linear way because the case itself never stopped generating new wounds. The families were especially direct in their criticism of how the prosecution had handled the case from start to finish. Steve Goncalves stated publicly that Prosecutor Bill Thompson had been weak, that he had run rather than fight, that he had prioritized his own convenience over the obligation to seek the most complete form of justice available. Whether that characterization is fair is something reasonable people can debate. What is not debatable is the specific gap Steve was pointing to. Thompson had evidence of stalking behavior. He acknowledged it publicly after sentencing. He chose not to charge it. He had the full scope of the forensic evidence. He chose not to present it at trial. He made decisions that simplified his case legally, while leaving enormous factual territory formally unexplored. A trial would have required expert witnesses to take the stand and defend their methodology under cross-examination. It would have required detailed public accounting of the evidence and what it meant. Without that process, the full picture of what Bryan Kohberger did, how he did it, and what preceded it was never formally established before a jury. Thompson chose a guaranteed outcome over a complete one, and the families were left to live inside the incompleteness permanently. The vacuum that the absence of a trial created did not stay empty. It filled immediately with misinformation. Online communities began claiming that Kohberger was innocent, that the DNA evidence had been planted, that he had been framed, that the investigation had been corrupted. Steve Goncalves found himself in the position of having to defend documented, established facts against people who had decided that their preferred narrative was more credible than a guilty plea entered in open court. He stated clearly and publicly that he knew without any doubt who killed his daughter, because that person's DNA was recovered on the knife sheath at the scene of the murders, explaining that certainty to individuals committed to a conspiracy framework was, in his own words, nearly impossible. He kept doing it anyway. The families developed complicated relationships with the media ecosystem that had grown around the case. Some journalists and content creators approached the material with care, sticking to verified facts and treating the victims as human beings rather than as content. Those creators earned the families' trust, and in some instances, the families agreed to speak with them directly, in order to push accurate information into a space that was being flooded with distortion. Other creators sensationalized the details, amplified unverified claims, and used the case as a vehicle for engagement rather than for understanding. The families could distinguish between the two categories immediately, and the exhaustion of having to constantly engage with both simultaneously was its own sustained form of damage. Steve made his position clear. He would keep talking. He would keep correcting the record. He would not stop until the day he no longer could, because Kaylee deserved someone willing to fight for her memory with the same consistency that the system had failed to fight for her life. Before Kohberger's arrest, specific details about the investigation began appearing in media reports that had not been officially released by any agency. Reports surfaced describing the murder weapon, describing Kohberger's behavior, and describing evidence found on his personal devices, information that was supposed to be sealed inside an active investigation. Some of those reports proved to be accurate. One specific report claimed that investigators had recovered images on Kohberger's phone that were relevant to the case. The presiding judge acknowledged publicly that a leak had occurred and stated the intention to investigate it with vigor. A special prosecutor was reportedly assigned to identify the source and pursue accountability. The families waited for results. Weeks passed. Months passed. No one was publicly charged. No findings were publicly released. The investigation appeared to dissolve without conclusion, and the families were never provided any substantive update on its progress. When the Goncalves family attorney brought the leak to the court's attention, the court's response was to place that attorney under a gag order. The lawyer, who had identified a breach and raised it formally before the court, was silenced. The breach itself went unaddressed. Steve Goncalves described that moment as the clearest signal he had received that the system was not operating in the family's interest. His attorney had done exactly what attorneys are supposed to do: identified a problem and brought it to the appropriate authority. The consequence was being told to stop talking about it. When the families asked prosecutors directly about the status of the leak investigation, they were told the matter could not be discussed. Investigators implied that work was ongoing, but offered no specifics, no timeline, and no indication that any real progress had been made. The families came to believe there had never been a genuine investigation, that the promise of accountability had been made to manage the moment and was never intended to be fulfilled. Several of the leaked documents bore watermarks from specific government agencies, which meant the origin of the copies could potentially have been traced. When families raised this with officials, the response was evasion. No agency claimed responsibility. No agency acknowledged the implication. The trail that existed was simply not followed. The leak investigation became the concentrated symbol of a broader pattern. Nobody faced consequences for releasing crime scene photographs without adequate family notification. Nobody faced consequences for the decisions families had objected to throughout the process. Prosecutors operated with enormous discretion and faced no formal accountability mechanism when families believed that discretion had been exercised poorly. When authorities made decisions that caused direct harm to the families, there was no institutional structure through which those families could compel a response. They could speak publicly. They could give interviews. They could meet with legislators. But the system itself did not have to answer to them in any binding way, and it largely did not. At the Latah County Jail in the period following his arrest, Bryan Kohberger's behavior was observed and documented by jail staff and fellow inmates. He watched television news coverage of his own arrest and was reported to have responded with the observation that he was on every channel. His stated favorite film was American Psycho, a movie centered on a fictional serial killer. He spent time studying other murder trials on court TV, analyzing case strategies and courtroom dynamics. He washed his hands obsessively, going through approximately 3 bars of soap each week. He showered daily and requested fresh clothing and new bedding every single day. That compulsive cleanliness was consistent with what investigators had documented after the murders, when Kohberger had thoroughly cleaned both his vehicle and his apartment before his cross-country drive back to Pennsylvania. An inmate who spent time near him described Kohberger as highly intelligent, but with eyes that communicated something deeply unsettling. The characterization that emerged from multiple observations was of someone capable of engaging with violence as an intellectual subject, while remaining entirely emotionally disconnected from the human reality of what he had actually done. He could study murder trials the way someone studies a craft, without any observable connection to the 4 people whose deaths had placed him in that cell. The question of why these 4 victims was never formally answered, and likely never will be. Kohberger visited the neighborhood surrounding 1122 King Road more than 20 times before the murders. Whether he encountered Kaylee Goncalves on the University of Idaho campus and developed a fixation from that point, or whether the targeting began through surveillance alone, was never established through the legal process. The investigation examined the possibility of a prior connection, but did not produce documented evidence of one. Judge Stephen Hippler stated at sentencing that Kohberger's motive may never be known. The questions that a trial might have at least approached remain formally open. Why the 13th of November specifically, when no documented trigger for that date has ever been identified? Why Dylan Mortenson's room was not approached when Kohberger looked directly at her and chose to leave? How he knew about the back door and used it to exit without leaving evidence that pointed to a specific entry or exit route? Whether the visits to the neighborhood in the months before the murders included interior reconnaissance, or whether his knowledge of the house layout came from other means. And the question that the DNA evidence itself raises without fully answering: if Kohberger had planned this carefully enough to visit the location more than 20 times at night, why was a sheath bearing his DNA left at the scene at all? Whether that represented panic, a miscalculation, or something else about his state of mind in those final moments inside that house is unknown. He entered a guilty plea. He offered no explanation. The answers, if they exist, remain with him. The house at 1122 King Road was demolished on December 28, 2023. The University of Idaho stated that demolition was necessary for the healing of the broader campus community. The Goncalves family had requested that the structure be preserved. Their request was not accommodated. The physical location where 4 people were murdered, and where evidence had been gathered, and where Dylan Mortenson had stood 3 feet from the man who killed her friends, was gone before the legal case itself had concluded. The university created a memorial garden and released a 3-dimensional digital model of the house for purposes described as educational. Campus safety protocols were strengthened. These were institutional responses that acknowledged what had happened, while simultaneously removing the most tangible evidence that it had happened at all. The families understood the university's position. They did not agree with it. That disagreement was one more instance of a decision being made without sufficient weight given to what the families needed, and one more instance of the families having no mechanism to change the outcome. 3 systemic failures emerged from this case with clarity that the evidence record supports. Universities operate within legal and procedural constraints that make it genuinely difficult to remove students whose behavior is documented as concerning, but has not crossed into criminal conduct. Prosecutors carry enormous discretionary authority with limited formal accountability to victims' families when those families believe that discretion has been exercised poorly, and victims' families, under existing law, have restricted rights and limited formal input into decisions that affect them directly and permanently. Bryan Kohberger will spend the rest of his life in prison. That outcome is documented, established, and final. But for the Goncalves family, for Dylan Mortenson, for every person connected to Kaylee, Madison, Xana, and Ethan, the case being officially closed is not the same thing as anything being finished. The legislation the Goncalves family is working toward, the conversations about institutional responsibility, the questions that were never asked in a courtroom, the record that was never formally built. All of it continues. Steve Goncalves said he will keep talking until he cannot anymore. That is not the statement of someone who found resolution in a guilty plea. That is the statement of someone who understands that the legal system delivered a conviction while leaving justice incomplete, and who has decided that someone has to keep saying so. If this series has given you something to think about, something that the standard coverage of this case never reached, then you already know what to do. Like this video, share it with someone who needs to understand the full picture, and subscribe to Keith's Crime Files right now. There is more in this case than what was ever presented in a single courtroom or a single headline, and this channel is the place where all of it gets examined with the seriousness it deserves.